are just a second away. I am going to now bring Wendy into the mix, and hopefully we'll be ready to get started with our where there is a will, there is a way. She should be here. Hi, Wendy. Are you there with us? We were just practicing, and I'm hoping that she's still there with us. I just popped her on hold for a moment, and we are going live. Hang on one second. Thank you so much for your patience, everybody. We will be starting in just a moment. I think I popped Wendy on hold for a second, and now here she comes. Hi, Wendy.
Hi, everyone. How are you?
Oh, thank you so much for joining us today. It's really exciting to have you here. And I am looking forward to talking to you a little bit about all this fancy will stuff.
Excited to be here, Kate. Thanks for the invite.
My name is Kate Corrigan, for those of you that are just joining, and I am a representative of Keller Williams Belize, and based out on Ambergris Caye. I do work in the selling and helping people buy property here on Ambergris Caye and throughout Belize. We're here today with Wendy Auxillou. She is a barrister and attorney at law, and she is based over in Caye Caulker. And I've invited her here today to speak to us about wills and Belizean wills, and specifically, well, we can talk about anything about Belize wills, but how they might be useful to you if you have a property here or assets in Belize, and whether there's a benefit to set one up, even if you have other things going on in different countries. So I'd like to take a little minute to talk about Wendy. She joins us today from her office in Caye Caulker. It's stunning. You just take her right off the boat, and it's on the left-hand side. Isn't that right, Wendy?
That is correct, Kate. Just a few footsteps away.
Yeah. Wendy is born in Caye Caulker and raised her children there. And I'm going to let her tell us a little bit about her journey into sitting in those beautiful offices and as an attorney, and how you got there. Can you tell us a little bit about yourself, please, Wendy?
I would love to, Kate. Thank you so much. Hi, everyone. As Kate said, my name is Wendy Auxillou. I'm about a fifth generation Hika Kenya. I was trying to get Kate to say that word. It's a little complicated, Kate?
Hika Kenya.
Hika Kenya is someone from Caye Caulker. If you're from Caye Caulker, you're a Hika Kenya. But I'm about third, fourth, fifth. I can't even remember how far back, but about a fifth generation Hika Kenya. I was born and raised here. I remember it vividly from in the old days when we didn't even have power. And when the tourism industry started, but sometime along the way, when my kids got to the age that they started university, we moved to Houston in Texas, and they went to university there, and so did I.
Oh, wow.
That's a cute tidbit, a little bit of trivia there.
So you all studied together in different college, in different universities?
Different universities. And once back in the day when I was of college age here in Belize, there were no universities. In order to attend university, you would have to travel to a foreign country to do that. And to do that, you would have to come from a family of means, and we certainly didn't do that. We didn't come from a family of means. So it's been a dream long in the making to become an attorney, but here I am, right?
Oh, wow. And I noticed that in your bio, you're admitted to the Bar of England and Wales, and also the Eastern Caribbean Bar. Did you have, and St. Vincent and the Grenadines? I mean, is that, Grenadines is so wrong. How do I say that?
No, that's correct. It's
Is it correct? Oh, goodness. So is that something that you, through just admitting the bar here, or did you have to go to those countries? Have you been there as well?
No, because there are several countries in the Commonwealth Caribbean or CARICOM Caribbean community that do practice the common law, which is the law that's derived from England and Wales. They allow people who have been trained, barristers that have been trained in England and Wales, to come back home to the Commonwealth Caribbean and be called to the bar here. So St. Vincent and the Grenadines is one of those CARICOM countries, and they allow cross qualifications, and so I was able to be called to the bar there as
Oh,
well.
lovely.
In Belize as well.
And you said you had 2 children. Are they still, are they back here in the country now, or are they still traveling the globe?
I actually have four children, Kate.
Oh,
But yes, I do have four. And I think you've met two of them. Giselle, who lives here in Kikaker. She
yes.
also decided to come back to her roots. So she's another generation of Hikakenya here. And I do have another daughter who lives in Belmopan, and a son and a daughter who live in the United States, one in California, one in Florida. So we're a multinational family.
Oh my goodness. And a little bit, I mean, I know these are very troubling times for everybody, and everybody's healthy and happy and safe and looking out for each other, I hope.
So far, so good, Kate.
Yeah.
That's
Oh,
all we
that's
can
good.
do. Knock on wood and hope everything goes good, right?
And Key Corker, tell us a little bit about that. How big is the island and how many people traditionally live there?
Kikaker is about, and I'm just going from what I learned in the history books because I've never actually taken a measuring tape and measured it, but
Of
I think
course.
it's about either 3 miles or 5 miles long, and it's about a mile wide at its widest point.
Wow.
And Kikaker is one, it's considered one island, but it's actually two islands because the island at its narrowest point was it was split in two. One of the hurricanes that came, the wave action just cut it into at its
Yeah.
narrowest point, and now it's two islands basically. But both of them, both parts of the island, both halves are known as Kikaker, and we just call it North Kikaker or South Kikaker. South Kikaker is the most inhabited part of the island. That's where most of the population of the village lives. But the north side is starting to become populated as well.
It is. I know I've been fortunate enough to go to a couple of the new resorts and houses over there, and they are very beautiful. I don't know that I'd be able to do that boat trip to get home, though. I do like just to be able to hop in my golf cart or chip home, but I know it's a very beautiful island. And now there's the split bar and that at the commercial area now at the end of the south side of the island, and you can actually swim across if you want. You have to be careful of the current, isn't that right?
That's correct. That's correct. And a lot of people do that for recreation, actually.
Yeah.
But most of the population is on the south side, and the total population of this island right now, I would say, is probably in the range of between 1,500 and 2,000 inhabitants.
Oh my goodness,
That's
that's not
small,
very many. It's a small
very small
community.
island. Right.
Yeah.
Right.
And they've done very well. You haven't actually had any active cases of COVID-19, have you?
None, but we were very proactive. We shut down our island.
Yeah, you were lucky.
As soon as they made they confirmed the first case, we shut down our island. So we're doing pretty good.
Yeah, nobody in, nobody out. That's fantastic. Well, hopefully it'll be one of the first places that people come back to visit. Now, today you're here to talk to us about wills and their importance. Now, being in real estate, when people buy a home, one of the things that I always say to them is make sure you tell somebody that you own this. Make sure that you let your children know how you own it. Last week we talked about with Ryan Roble about different ways to own property, whether it be different types of title, shares, those types of things, just so that those that are going to be inheriting things when you do pass away have an understanding of what you've invested in, how you've invested in it. But it's my understanding that a Belize will can be very beneficial. Could you tell us a little bit about Belize wills, or as much as you can about Belize wills, how they're perhaps set up, and what we would need to do to be able to get involved with that?
Great question, Kate, and I would love to explain. For the people that don't know, and I'm sure most everyone probably knows what a will is, but for those that don't know, it's just a declaration that you make every living person makes in a prescribed form. There's a certain format that it has to be in order to meet the specifications of the law. And it's made in contemplation of death. And it's basically a request to your beneficiaries or to your heirs or the people that you're going to leave your estate to, if if that's what you want. And it's a request to them stating basically how you would like your estate distributed at the time of your death. So that's what a will does. You can have a will drafted in any country in the world. The reason, the most recommended reason to have a will drafted in Belize that suits the laws of Belize is specifically for that reason. Because here in Belize, we know what the requirements are that are specific to our laws that are that are made here. And so we know that they fit the requirements, and you would not have a problem probating those in the courts here in Belize. So that's the main reason.
And why, if somebody has a will in the United States, and please, if you are watching, please post your questions. We want to hear all of them, whether they be specific ones to you, or whether you have stuff going on. Please post your questions. The reason I'm looking down a little bit is so that I can be looking at my Facebook too. So those of you watching on Facebook, please post your comments and your questions in the comments box. We'd love to hear from you. And those on the Zoom call, please post your questions. We are ready to answer them. So if somebody has, I had this one emailed to me earlier today, if somebody has a US will, mm-hmm. and they put it in their US will that they want their heirs to own the Belize property, why would they need to have a Belize will as well?
Well, technically, they wouldn't need to. The problem with the wills in the United States is that the requirements in Florida are different than the requirements in Texas, are different than the requirements are in California, and they may be different than the requirements in Belize. So it's more beneficial to get a will done in Belize. It's very simple to do. It takes, any attorney could draft one for you. Once they have the information that you would provide to them, and I can go over that a little bit later, what that information would be. But once we get that information, I know at our firm, we are able to draft wills within 24 hours. So they're pretty fast to do, and they're not very costly. It's about $750 Belize dollars or $375 US dollars. But to answer your question, if you have a will that's been drafted in Texas or Florida or wherever, and it's been probated through the court system there. You can also certify that in the courts of Belize here using a process called resealing of a grant. So either way, there's going to be a process that you have to go through the court system here. Whether you have a will in Belize, in the United States, or whether you have one here. So to answer that first question, yes, you could your will that you draft in Florida, once it passed through the court system there, and the court system there has certified that it's a genuine and good will, and it's accepted as the will of the testator, then you would be able to process that through the system here under a process called resealing.
Right. Okay, but it would take a lot longer, would it?
It would take a lot longer, and there are some requirements. For example, in order for you to process a will here in the court system, your executor would have to be located in Belize. It's just a very difficult process if the executor of the will is located out of the country. They would have to, it takes several steps. You would have to find someone within the country here to give a power of attorney to be able to receive
right.
your grant or your will, or to even process the will that you've drafted here in Belize.
Okay. So for those of you that are just joining us, my name is Kate Corrigan of Keller Williams Belize, and I'm joined here today with our guest speaker, Wendy Auxillou, attorney at law based over in Key Corker. And she's talking to us today about the benefits of a Belizean will and why it might be important for you to set one up, specifically if you have property. Are there any other assets that you can have for wills that you can put in there?
Yes, we here we recommend that the wills that are drafted in Belize, which are specifically drafted to meet the requirements of the laws of Belize, that they only contain, we just recommend that they only contain assets that are within the country of Belize themselves. You could have, for example, two wills. A testator could have two wills, one that's valid in the United States for the assets that are in the United States, and one that's valid in Belize just for the assets that are located within the country of Belize. And it makes it easier to separate those assets and to just process them through the court system, put it that way.
Right. And so what do you need to be able to, so I bought my property, should I start this process during closing, or after I have time? I mean, obviously as long as time allows for my help. When would you suggest, when somebody signs an offer for a property, should they start the will process just in case something happens during that time? And would that be really great?
If you've put money down on a property, even if you haven't closed on the property yet, closed on let's say the purchase of the property yet, if you put good faith money into an escrow account to purchase property, let's just say, you have what is called an interest in that property. So you do have an asset. That's an asset that you own. You can start drafting a will from then. You can wait until you close on your property sale. Any one of those is fine. But it's really important, most important than anything else, is just for you to have a will. You can draft a will today, and a will is a living document. If you purchase more assets along the line, or divest of some assets along the line, then you just do updates to your will. You add codicils to your will, or if you change your mind about a beneficiary and you would like to, remove someone, add someone else, those are all revisions to the will. But what's important is that you have the core will. You have something tangible that you can take to the courts, that your heirs, your beneficiaries can take to the courts and have them probate. I should add here, Kate, that if someone dies intestate, meaning they don't have a will, there are provisions in the law to distribute that person's estate as well. But the way the assets of that estate would be distributed would be prescribed by law. They wouldn't necessarily be the wishes of the testator or what the testator would have liked. So,
right.
So if the wish is honored, it's best to have a will.
It sounds. So your best advice is to just have something written down.
Right.
However you would like to be able to do that. Now, I have some questions. Now, I'm going to try and get to everybody. There is one question. I thought a person could only have one last will and testament. And I've had this question before. Thank you very much for your question. And I've had this before where I was told at one point, and I'm not an attorney, so I refer them to a professional. They said, well, if we write another will, does that supersede it? Does it counteract it, as it were?
Well, usually when you draft a will, it says that this is your last will and testament, and that all other wills and codicils are cancelled, basically. Normally, that's what a will would say. However, that's just put in there. That's a clause that's put in every will. So the most recent dated will is the one that's the one that's probated in the court, that the court accepts as the real will, as the valid will. However, if your will that's drafted in Belize, it doesn't say, it says that it's the last will and testament for your assets that are located in Belize. It says specifically that it's just for your assets that are located in Belize. And you can claim in your last will and testament that you do have another asset, another will, drafted for your assets that are in the United States. And you make that clear in your will that this is a complementary will to a will that you have also drafted in the United States, then that would be valid. You just have to be clear about it in the will that you're drafting.
Okay, thank you so much. I hope that answered your question, last will and testament. It's from an anonymous attendee, so thank you for joining us. Michelle Duncan has asked a really great question. Hi, Michelle, thank you so much. So the question is, if you purchase a condo free and clear from a US owner, but after paying them in full, apparently it's not been granted title. But they advised a Belize attorney that they had the title. Apparently there is a discrepancy with the amount of GST paid. As it stands, everything, if everything's been paid to the owner, does not own their condo, but the condo is still held in the development. Okay, so this is more of a property ownership
Legal
question.
question.
Is this something that you can help with? I mean, this happens sometimes here in Belize. You
If
know,
you,
when somebody purchases something, but the title hadn't actually been released to that owner's name as yet, what can happen in that instance?
yeah, if you buy a condo and it's paid in full and you receive your strata title, you own that as the legal owner. You're the legal owner of that condo.
Right, okay.
If you paid for the condo but you haven't received the title hasn't, the strata title hasn't been issued in your name for whatever reason, you have what is called interests. You paid money. This is something, you have what is called equitable interest in the condo, and so you still have value. There's some value to your estate that you can claim in the courts.
Right, okay.
Called equitable interest. It's not legal interest, but there's still interest that you have. And
Yeah.
you can pass those on to your beneficiaries in a will, yes.
And you can pass them on in the will and do those types of things as well. That's a great question, because I know that quite often here, especially on the islands, you know, condominiums are built. They are bought initially by people, and they need to be able to sell those before the government has actually issued those titles. So what can happen is that somebody can buy that, and that would be what we, you know, and you would work with an attorney or a professional to be able to help you establish what, how you would take first title of that property. And then once you actually own it, you can only put it into a will once you once you have the title. Is that correct, or could you put it in as a promise? Does that make sense?
What we do when we have a document that we give our clients, and it's called a will planning guide. So we ask what we do, because we try to have a comprehensive listing in the wills. And this isn't in the will, but it's an addendum to the will. It's just a list of all the assets, the known assets. We ask our clients to just list what their personal property, the personal property that they own, that would be their bank accounts, their vehicle, their golf cart, anything that's not real estate. That's your personal property. And so you list those, and it's just so your beneficiaries can find them. If your beneficiary doesn't know, even if you have a will, if your beneficiary doesn't know that you have an account at Atlantic Bank with $10,000 in it, how would they know to go and locate it? They would not know. So we just as a matter of courtesy and for ease of reference for the beneficiaries, we add those at the end of the will. But in that same, and then you can add the real property, which is the condos or whatever you own, what you have legal title to. And then anything else is called your residual estate, including the interest that you have. If you paid for your condo, but you haven't received the title yet, it's being transferred, but you haven't received ownership of it yet, or even if you're in the middle of, you've signed an agreement for sale. Most agreements for sale, they would say somewhere that it binds the heirs and executors, that kind of thing. So even if you paid the deposit, the good faith deposit on a transaction, and something happens, God forbid, and you pass away, your heirs are entitled to either continue that sale, or depending on what the agreement for sale says, may be eligible for reimbursement of all those of the money that you have paid, depending on what the contract says, So it is an interest that you own. It's different legal title, but it's an interest. You have some rights to it. So your beneficiaries can claim that, yes.
Yeah. And the original sales offer that was signed for between you and the person that sold you this but couldn't transfer title, that would stand up to should something happen to you between now and when that title was released, that would stand up to say that your heirs and beneficiary would take on that responsibility, and they do own it just like you do.
Correct.
Perfect. Now, how does it work with a living trust is another question that we have.
I don't really do trusts, I'll be honest, Kate.
Right?
I'm sorry. I do work with the office of Lisa Schumann, who's a senior counsel, and I usually just refer my trust matters to her.
Right. Okay. Yeah, and that's a great question. So if you would like more information on the Living Trust, do email me or message me or leave a message, and we can certainly put you in touch and make sure that you get that question answered specifically to your needs. A couple of other things. I'm going to try and get a bit techie here for a second. Try and go back and see. Whether we have any questions on the Facebook page at all. If anybody's watching on the Facebook page, do you have any questions? Is there anything that I can help you with? Put your comments and questions in the comment box. I would love to be able to help answer those for you. If you're on the Zoom call, please let me know and say hi. And if you have any questions, let us know. We would love to answer them for you. So, what documentation? So I know I need a will now. You know, my other half, my husband and I, we've just bought a property. What do you need from us to be able to? Okay, Wendy, I need you to set me up a will. I don't need anything fancy at all. What are the next steps?
Yes. So there are some basic requirements. And let me just go over these. The will must be in writing and signed by the testator. There are some legal jargon that has to precede the first few paragraphs of the will. But in a nutshell, the will must be in writing and signed by the testator, who is the person drafting, for who we're drafting the will. That person is called a testator or the grantor. The testator must sign the will. After he's drafted his will, he's listed all the assets and who the beneficiaries are. And I can go over, if you would like me to, what these things are. But the testator is the person who's drafting the will, for whom we're drafting the will. The executor is the person who the testator gives the power to distribute the estate upon his death. And the beneficiaries are the people who stand to benefit from the estate, who the assets are going to be distributed to. The executor and the beneficiary can be the same person or same persons.
Right.
There's no problem with that. If you have a will and you're planning to get married, it's probably a good idea to wait until after you're married to draft your will, or to draft your will and draft a new will after you're married, because marriage negates or cancels a will. So just so you know that's one of the quirks in our law. But anyway, the testator must sign the will before two independent witnesses, and all parties must be in the room at the same time. So everyone must be in the room when the will and the witnesses, when the testator and the witnesses sign the document, and the will must be dated.
Right, okay. So if you're purchasing a property from afar and you're not here for the closing of it, you can't actually get the will done in Belize unless you're here present, or can it be done by power of attorney?
Yeah, no, no, it would have to be signed in person. And in a matter like that, in a situation like that, what we would do is just forward the drafted will to the person wherever they are, and then they would be able to find two witnesses.
Oh, perfect.
Wherever they are, to just two notary publics or something like that, that would certify that the testator signed the will in front of them.
That's brilliant. So if there's another question, thank you very much. If you have a Belize will, is it valid in the US? So can you put US assets in a Belize will?
I'm not trained in US law, so I'm not sure. That would be a United States jurisdictional issue. I'm pretty sure it probably varies by state, and so I would not be the appropriate person to ask that question to. It would probably be an attorney in the United States. I'm not sure if they are.
Thank you. So you'd have to check with them in the States when doing that. What is the standard court process for dealing with a death and probate in Belize? Another great question. Thank you.
Well, these are two questions. It looks like how to dealing with a death There's a process here, and I'm not really sure what it is, but I believe it's reported. If there's a debt, it's reported to the health system, first of all. And automatically, if you're an American citizen, and I know your audience is probably not all American, but this probably relates to anyone of any nationality that's a non-Belizean. It's reported to your embassy, and then the embassy, they have their own protocols and procedures to deal with debts relating to citizens of their country, basically. To probate the will in Belize, it requires filing an application to the courts. And even if you're testator, if it dies intestate, there's also the requirement that an application needs to be filed in court. It's just a different application. But to probate the will, there's an application that needs to be filed in the Supreme Court. It's published. The fact that there's someone is the executor or someone is trying to, claim to probate this will, it's published in the government gazette, a number of publications in the government as gazette to make an announcement to the public per se that this will is being probated in case anyone wants to object. And then after, I believe it's 3 publications, they issue the grant of probate to whoever the executor on the will is. So it's a system. It takes a little while, but we get there.
So how long does it normally take to do that? So if I come, so I live in a different country, and my grandfather has passed or something has happened, and I find and I go, I know he's got there's a copy of the will in his safe, and I come along and I say, hey, I'm the I'm the beneficiary of this will. What do I have to provide for you, and how do I have to be in here in person, or what has to happen? Do I have to provide just the certificate of death, my identification, and give that to you, and you can execute the will that way for me?
Yes. There are certainly different variables, Kate. For example, if your mom made you the executor of her will and she passed away in Belize, but you're in England, you would be unable to probate that application in the Belize courts because you're not domiciled in Belize. In that instance, then we would request from you a power of attorney, which you would assign either to your attorney or to someone else that you know locally in Belize that could be your executor, your attorney to probate the application. And yes, what would be required for whoever is filing the application for probate, whether it be yourself or an attorney that you give a power to, you would need their identification. If it's under a power of attorney, you're granting the power to someone inside the country, then we would need a power of attorney signed by you and your ID to prove that you're the one that signed this power. And we would need IDs for the person who's getting the power. So ID for the person granting the power and ID for the person receiving the power, who's being granted the power. And we would need original death certificate. If you're a relative, for example, well, this would not relate to someone with a will, but if someone died intestate, it's your mom died without a will, and you're claiming her estate, which would be under a grant of administration. If the person dies without a will, I know we're talking about a will today, but if this person dies intestate and you're applying for a grant of administration, then you as her child would need to provide a birth certificate, an original birth certificate to prove your relationship to your mother,
Right.
So you would be able to file in the courts. They would accept your application in the courts as a next of kin to gain control of her assets.
Oh, goodness. And so, again, another great reason why, otherwise, during a time of loss and grief, having to do all of that to try and claim property or assets over here at that time, it's just easier if there's a will, you have to prove who you are, and that can all be taken care of because that's what's been written out by the owner of the assets here. So could you remind us again, how much does the basic will cost in US dollars?
It's 375 Belize dollars.
375 is US dollars and
US
750.
dollars, 750 Belize.
750 Belize. So that's not, you know, when you're purchasing a condominium, a home, or anything here, it's not a huge amount of money to just make sure that something is written down and that people know what's what your wishes are. I know that if you know, like my partner and I, when we have our house together, you know, and my half will be given to my daughter and his half will be given to his family, but both of us want us to be able to live in the home and enjoy it until the other passes. But if it's ever sold, that's how it would be divided. So, you know, that's what you would call a simple will, a basic will, is that right?
Correct.
I mean, I have one daughter.
Correct. We do send what we call, we have prepared some, and I don't want to show it here, you probably wouldn't be able to see it anyway, but we've prepared a document called a will planning guide, which has some basic questions. For example, the name and address of the testator, whether they have any previous wills. If so, do they have a copy of it? We would need to see those before we draft a will for them.
Right.
If the property pertaining to the will that they're asking us to draft is located in Belize, what kind of property they're bequeathing? Is it money? Is it real property? Is it, you know, assets, vehicles, golf cart, whatever? We also need to know the marital status of the testator for various reasons. But like I said before, if you get married after you've drafted a will, a Belize will, marriage cancels. It just revokes the will. So that's something you probably need.
It would automatically go to your spouse, is that correct?
It doesn't automatically, no. No? But it goes, you could draft a will after you get married. Post-marriage, you could draft a will, and then that would be valid. Marriage just cancels the will that you've made before the marriage. But it doesn't stop you from drafting another will after the marriage.
Right, okay.
To separate the assets. But it's important because according to our laws, we need to know that because according to our laws, a marriage revokes a will.
Right.
A will that was drafted previous to a marriage.
Goodness. So is there another great question here? Is there an inheritance tax in Belize?
There is some tax that needs to be paid, and it's calculated on the value of the estate. I don't have the calculation in front of me, but it would go along the lines of what the stamp duty, it's a stamp duty you pay.
So similar to the 8%. So between 5 and 8% would be the inheritance tax.
Somewhere along that, but there's a sliding scale per se, and I don't have that information in front of me right now. But the Supreme Court, when you file the probate application there, they make a calculation of what taxes they need to collect from you. I think a probate application where the value of the estate is not more than $20,000, there's no taxes payable on that.
Right, okay.
Very low, but
yeah, so it's very similar to when you purchase a property. There is a transfer tax where it asks for you to transfer the title, the name on the title, and a new one issued and signed by the registrar there. Then that is a fee to non-citizens of 8% and Belizeans of 5%. I think that is. So it's very similar to that basically what you're doing is you're transferring the asset into your name. And so it is a change, and I can, that makes sense. It might not be what you want when you get given a gift, you have to pay for it, but it is still going through that process. So what does it cost for an attorney in Belize to be the executor of the estate?
Well, okay, I have a fee schedule here. I don't have the exact figure in front of me, but I think it varies based on the value of the estate.
Right.
And I can look it up, but I can just send that information to you. You want me to look it up?
No, that's fine. I mean, so it would be valued based on
the value of the estate.
Yeah, and are we talking a percentage, or is this sort of, $500 for this, or $1,000? for this. You can look it up if you'd like. That would be great. It looks like you're going back into this. You've got you just dipped into somebody's veranda there. Is that in Placencia?
Let's see.
I'm just going to look on this other screen. Is that the condominiums in Placencia there, Wendy, your background?
Yes, it is. It is.
Yeah.
How do you know? It's a percentage of the gross value of the estate.
Right. Okay. And what is that percentage, or does it change?
It's 1.5% of the gross value of the estate. 1.5%.
Right, okay. So to actually execute a will is more or less the same price as it is to transfer a property, because it's usually between 1% and 2% for your attorney fees to buy a property, and then 8% for the transfer tax. So it's exactly the same. You need to make sure that there was an allowance in your will to cover this cost if you didn't want it to be a burden to your beneficiaries. So leave that amount in your Belize dollar account for them to be able to cover these fees, and it be easy, and have Wendy there to execute it for them. So for expat residents, are living wills important? Great question. Thank you, Anonymous.
I don't have an answer about living wills, Kate.
Okay.
We don't have that concept here. We do have trusts that you can create, but I personally, I don't practice trust law. As I mentioned before, I have a senior counsel who does the part of our law practice. So
right, okay.
I don't have an answer to that. I'm sorry. I wish
All
I could.
right. But we can certainly connect you if you'd like to send your information to me or Wendy, and we'll be going through Wendy's contact information very soon. But you can always reach out to her directly, and we can answer all these questions specific to your requirements and what you hold as assets here in Belize. As for a transfer tax, what if the beneficiary does not want to pay the fee? So if they don't want to pay that inheritance tax, what would happen there?
I just want to make a clarification, Kate, that I'm not entirely sure if the inheritance tax is 8% versus 5% kind of thing, because I don't have the information in front of me, and I don't want to give incorrect information. But there is a tax. I just want you to know. It could be less. It probably wouldn't be more than 8%, but it could be far less. I'm really sorry that I don't have that information. But but I can do it for you. I can look it up for you, and then I can provide it to you, and you can add that maybe.
Brilliant. I will put it in the discussion or email you out after. I can email that out to all attendees that are watching now. So if there's any questions that we haven't quite touched on or we need to go back to, when you can get back to us with the answers, and we can email those directly to you as a follow-up email. Thank you for your great questions. If the beneficiary doesn't want to pay that tax, what happens? Do they not get to receive their property?
No. There's only 3 things that could happen with the property. Number 1, you can file a probate application, an application for grant of probate in the court to process the will, to have the will processed through the court system and certified. You can not provide the will, which would, in which case, if there was no will and you are a beneficiary, you are a family member who wants to claim the estate, you can apply for what is called a grant of administration, and then the estate would be distributed according to the laws of intestacy in this country. And the third thing is, you could not accept you cannot accept the grant that's being made to you, that you could not accept what's being willed to you in the will, and in that case it would revert to the government. Right,
okay. Goodness, there's so many different things, and is it very specific to the individual's needs as to where wills and the setup of them are? I mean,
most of them are, in the sense that wills are very personal. Some have family members that they like and they would like to leave their estates to. Some are more philanthropic and community minded and they want to leave their estate to charity. I know someone here in Keycocker who just recently, she had a hotel and she passed away and she left her hotel to, I believe, an animal charity. I think
Right.
it's the dog pound or something like that, but or a
Okay.
medical hospital, an animal hospital. And so that NGO gained, that non-governmental organization gained control of the assets of that estate because it was willed to them. And so they operate the hotel and the proceeds from the hotel are given to the charity that they left
Oh, wonderful.
the property to. So it's a way to generate money. If you are charity minded like that, then you can use your, and you don't have anyone to leave your assets, so you can leave them to an organization that can use it to do good for the community as well. So it's not just the persons that you can leave your assets to.
Yeah. So you can leave your money to whoever you want or whatever you want.
Whomever you want or whatever
Yeah.
you want. I would like to add one more thing, Kate, that I didn't get to talk about. Normally in a will, we can insert a paragraph or a covenant that, a paragraph that specifies what you would like done with your remains. I think a lot of people have specific wishes, you know, whether it's to be cremated or buried or transported to their homeland or whatever. And so this is a good way if you include those instructions in your will for your wishes to hopefully be
Carried
granted.
out as you want
Yeah,
them.
carried out. Yeah, so we can include that in your will as well. If you have minor children and you're a single parent, for example, and you have wishes as to what would happen, you would like to see happen with your minor children, in case you pass, you can include that in the will as well.
Right, okay. Oh, goodness, there's a couple of other questions, but I think we've covered most things now. Are you looking at the same questions too?
I'm looking at the questions here that were sent, only the ones that were sent through Zoom.
Yeah, that's correct. So if two people are in a room and they, or three people are in a room and they write on a piece of paper what their wishes are and have that notarized, can that work? Would that work in the event of your death?
Well, it's very specific. A person can write their own will, but as I mentioned before, there are specific requirements. We have a law in Belize, a piece of legislation called the Wills Act, which sets out the requirements for, you know, the way wills need to be drafted. So it's best if you get at least a consultation, if you secure a consultation with an attorney, at least to be guided as to the proper format for the drafting of the will, because you don't want to go through all of that work just to find out when it gets to the court that it's not valid, they don't accept the document. And we've had that happen to a number of people. It's not necessarily that you have it notarized. As a matter of fact, a will doesn't even need to be notarized. It just needs to be signed by the testator in the presence of two witnesses who will testify on a document that they were present when the testator signed the will and that they saw the testator sign the will, and basically that the testator was in what we call had capacity. They weren't incapacitated mentally in any way. So they were able to sign the will with a good mind and clear head, that, you know, they weren't coerced in it. So this is what the witnesses do. And it doesn't have to be a notary. A notary is fine, but it doesn't have to be a notary.
Right, okay. So we've had some really, thank you so much for participating with all of your questions. This is the first time I've worked with the Q&A rather than in the chat. And so, you know, thank you for your patience with me whilst I've been trying to work through those with Wendy today. Now, Wendy, you are based in Keycorker and you have law offices that not only cover the writing of wills, and just to recap, please correct me if I'm wrong, it's always a good idea to have a Belizean will, especially if you own property and if you live here full time, and you can also put in there your wishes at death. If you want to be cremated, if you want to be taken home, that can be put into that will. A basic will would require all of the people who are a part of it to be there in one place and have that signed all together. Is that correct? And it would cost about 375 US dollars, at 750 Belize dollars. And there's variations of that, and everyone is different. If you just wanted to get something in writing, do it within a day, you could do that very quickly. So I think that the 24-hour thing is if you actually did have an accident and were worried for yourself. You know, I know in today's environment, people are thinking, hang on, if something did happen, am I set? So just having this basic piece of paper would help people. Is that correct?
Correct.
Perfect. Whew. I feel exhausted. I hope I understood while I was trying to look at questions and things. So what else do you do in your offices there?
I mostly practice civil law, and thank you for asking, Kate. I really appreciate it. I mostly practice civil law, which means I don't do criminal law. I don't go to court. I'm not a defense attorney. I don't go to court and defend people in criminal matters. But I do land law. I do real estate closings as well. And I do any other matter that deals with land. If you need a first registration, if you're trying to distribute the assets in a, that were left behind in an estate, if the executor is trying to distribute these assets, we can process that paperwork and provide it, process them through the lands department for you. We also practice contract law. We do company formations or corporate law, and some landlord and tenant law, and wills, probate, and succession. So those are the ones. Those are the main ones.
That's tremendous amount. So you could help with drafting lease contracts. And so if you purchased a property and you wanted to make sure that you had multiple units within a property and you wanted to make sure that your lease agreements were in line with Belizean law, you would be able to help people with those?
Correct. With lease agreements, gosh, I forgot what I was going to say. I just got a text and got distracted. Sorry. But yes, with lease agreements and most of our work, for agreements for sale, that's what I was going to say actually when I got distracted. But right. if you're, well, I don't want to take away your, that's the work that you do basically, but.
No, it's fine.
Draft agreements for sale as well.
Right.
We do represent buyers and sellers in land transactions. We draft wills. We can probate wills. We can probate. We can file applications for grants of administration. If you have a relative that's passed and they didn't leave a will, we can do the resealing of your foreign will if you need someone to do that for you. We do company registrations. If you would like to form a company in Belize, we can do that for you. My law partner, like I said, the partner who works with me, the senior counsel, she does those estate matters. I'm not really well versed in it. I should probably learn it, but.
It sounds like you've got enough to manage there. Nobody succeeds alone, do they, Wendy? So it's important that you have great people to work alongside you. Well, I don't know whether there's any more questions, but I think that we've been chit-chatting what I thought would be about a 20 or 30-minute interview. I do seem to not be very good. And I so love it when I'm learning all of these wonderful things. And I know that these things are really important to the people that are looking for homes, trying to make a life in Belize, are already in Belize, and just thinking, did I do it right? Is there anything else I can do? And how can I make sure that everything is correct for me? So I want to give a huge thank you to you. Now, if people want to get in touch with you directly, how do they find you? And what's your contact number and email?
I have a website, and I would probably have to spell this out, Kate, because I have such a complicated surname. But my first name is Wendy, W-E-N-D-Y, and my surname is Auxillou, A-U-X-I-L-L-O-U. So my website address is wendyauxillou.com. And on there, you can find our email address and our contact information. But here in Belize, it's country code 501-610-8255. 1877. That's the 1877. So that's the phone number for the law firm.
Thank you very much. And as we mentioned before, if you're going to visit Wendy, you get off the boat, you take a right, and it's on the left-hand side, overlooking the water. It's just literally a couple of steps away from where you arrive on the island if you arrive by boat. And it's just a great location, a lovely place to sit and discuss your assets and moving forward in next adventures. So thank you very much. My name is Kate Corrigan, and you can contact me on kate@frontstreetbelize.com. You can see this event. It will be posted after having a few edits. Get rid of a few ums and a couple of little mistakes, I'm sure. But you will be able to see it on my events page. That is on Front Street Belize /events, and you'll be able to see what's coming up next week, what's happened in the past. Events and interviews, and you can also catch it on my YouTube page, which is also Front Street Belize. Thank you so much for joining us today, Wendy. It has been an absolute pleasure, and thank you to all of the attendees that have joined us. It's been great to see you, and those watching on Facebook, either live or watching a watch party, thank you for joining me. Please send us your questions. Wendy and I will get together and answer them. So thank you, Wendy.
Thank you, Kate. And I just want to say before I go, to everyone who's joined your podcast today, you picked a great person to help you with your purchase, your property purchase in Belize. Kate is such an amazing individual. She's reliable, professional, and she's just right up there. She just started her own real estate business, just set up her new office in San Pedro. So pass her link around. Let your friends know that you've reached out to the right person.
Oh, thank you, Wendy. And I know that our clients
success, Kate.
Oh, thank you so much. It's always wonderful to have you as support to not only to our business, but to our clients that we work with you. Thank you very much. I know you've been a great support to Keller Williams over the years, and we appreciate you. So thank you. Thank you, everybody. See you again next week, Thursday at 5 Belize time. Thank you, Wendy.
Thank you, Kate. Bye-bye.
Bye-bye.